Welcome everyone to the Arlington Heights Memorial Library Online. My name is Barb and I'm an info services librarian. And I do planning for financial programs. Our program tonight is Special Needs Trusts, and our presenter is Benji Rubin, an attorney at Rubin Law.
Thank you guys for attending virtually tonight and giving us some of your time this evening. So hopefully we'll get a lot of good information out there and answer questions at the end that you may have. The starting point I'd like to begin with is why do I have the law practice I have, and my father found this practice, and I joined as my brother Mitch, and mentioned some of the intro slides there. He has severe autism. He lives in a group home run by Clearbrook, largest agencies in serving people with IDD, and he's an out prospect. His group home is, and he works at our office once every couple of weeks. It used to be like consistently. In the pandemic, it was a while that he was not doing that and was back in a bit. So that's Mitch, and I believe I still have a video. So introduce you to myself.
And first place for the goal from Clearbrook is Benji Rubin.
That was a good day at Special Olympics. My brother would have quite the meltdown if he got a ribbon. Sometimes he wanted to get the medal, participation ribbon. So my father would learn over the years. He would have a medal in his pocket. The previous time he won a medal, hand him out, "Oh, here, I'll take the ribbon. Here's your medal." But he loved winning medals. That's those things. So, anyways. A little bit about being a sibling. I think every time I have an opportunity to speak to any group about special needs planning, whether it's parents, professionals, or siblings, other relatives, or other individuals that are part of this world, I think siblings are an important thing to talk about, and that is never talked about. Obviously I'm still myself, and that's my perspective. When parents talk about having a child with intellectual developmental disabilities, or maybe mental illness, or some other nature of their child disability or their family's disability, we tend to see parents have kind of life like before they had a child with disabilities, and then life after them. It's fork in the road, and things change, and how they view things. Siblings also have a different perspective on things because of having some disabilities. But I think it's important to note that it's different than the parent's perspective. For one thing, it's very likely that the sibling doesn't have much concept of what it's like not to have a family with disabilities. Myself, as a younger sibling, I do not have any concept of what it's like. Even older siblings, maybe it was only a couple of years before they had their sibling with disabilities was born, and so from their very earliest memories, they have aspects that impacts. Growing up, it would affect a lot of different things. One is our friends, right? The prism through which we would kind of filter who we want to be friends with or not, or who we choose to surround ourselves with, would often be people who would certainly not make fun of our siblings, certainly people who would just have more understanding, maybe more mature. You tend to see that siblings, on average, there's definitely a wide diversity of siblings and their experiences, but a majority, or certainly a disproportionate, are more mature than their peers, and there's good reason for that. Dealing with some pretty big issues and challenges that a lot of their peers are not thinking about or were shielded from. And so vacations were an adventure with my brother, but it was not relaxing. It was very much you had to be on, and it was vacation with my brother. It was not a vacation. Very much kind of just, it was always planning ahead of what would be, try to enjoy ourselves when we could, but it was always kind of manage a little bit about what what's the next step, and what if this goes off the rails, and is there a fire alarm anywhere near here? Because, especially in non unfamiliar environments, he loves to put fire alarms, especially if he doesn't like what's going on, or he's frustrated, or just whatever, wants to change what's going on. So anyways, definitely an adventure. In trips to the grocery store were also different. My brother would occasionally have a meltdown. This was growing up, late 80s, early 90s, especially, where the awareness of what autism was, some of the developmental disabilities, what that was like, there wasn't that kind of level of just general awareness. And so when people give dirty looks, they would make comments, they would say all kinds of nice things, and that would definitely be part of the living experience of a sibling. Certainly those who've grown up, from a millennium, not exactly, it's on the long run, crazy old times. So that is certainly part of the sibling living experience. I hope and expect that siblings, Gen Zers and this next generation of siblings, are not experiencing that, because there is a lot more. There used to be a lot more understanding, hopefully compassion, empathy, those things. But the big thing that I talk about a lot is this understanding our future responsibilities, which brings us back to the topic tonight. It's knowing that it's very likely that our brother or sister is going to outlive our parents, and therefore it's going to be down to us to be there in some capacity. Maybe it's their guardian, it's their advocate, all kinds of ways, and that really affects a lot of things. So there was a study done by Easter Seals, study with Easter Seals, I forgot which organization, but they were looking at siblings, and they would interview about 100 siblings, and they found that siblings were thinking about, talking about, considering, they really kind of spend a lot of time thinking about what's going to happen when their parents are gone. What's their responsibility to be like for their sibling. And one of the things that I always emphasize is that it's so important to bring the siblings into the planning process at an age appropriate level, because having to be this black box that, oh yeah, mom and dad are taking care of it and I'll protect you from having to worry about that, that's not helpful. It's not going to serve the sibling, and it probably just leads to more anxiety. So we really want to understand that there are these siblings, they're thinking about it, they're talking about it, they're maybe with their peers potentially, but they're certainly thinking about the ideas of what's going to happen when mom and dad are gone. And we want to, as much as possible, try to alleviate some of the concerns they may have, and give them more information as they get older, about what that might look like, what the supports and services are available, and how are we going to work towards building that full life in the community for them, so that they are not going to be moving in, for example, with their brother or sister and their future spouse and children, and all the things that affects. And by the way, when it comes to planning, siblings, when they're dating, for example, are oftentimes thinking about, when do I bring up my sibling with disabilities? And in fact, this is part of a real big part of my future and my responsibilities, because there's a push-pull of, wait a second, or a battle, and we're trying to balance, wait a second, it's my life, going on this date for, why does my sibling have to be front, stage, and center of every single aspect of my life, including my dating life? But on the other hand, we may say, wait a second, why wouldn't I bring up sibling soon? Because what's the point of dating this person if even going on a third, fourth, whatever date, if they're not going to be committed to understand that if this was to go into a serious direction, that this is a part of my future. This is part, they have to be part of that and understand what that role is going to be. And it's very different for a sibling to tell their respective date or new, boyfriend, girlfriend, whatever, that they're going to be, this is part of their future, of being an advocate, of being a guardian or trustee of a special needs trust, or all these things, versus, oh, they're living with my mom and dad. I have no idea what's going to happen. And if we don't figure it out soon, and something happens to my parents, they're going to be moving in. It's like, if you were married family. And we've seen siblings get divorced because of the pressure put on their marriage by those kinds of crisis, scenario. So that's another piece to why it's so important to do planning for the future, not just estate planning and special needs trust and guardianship or powers of attorney or support decision making, whatever it might be, but also the rest of it, figuring out what does that world look like, supports that individual needs to live that whole healthy, fulfilling life, independent life, as independent, as they can be, certainly independent of the family relying on them 24/7. So I'm the president of Supporting Learning Brothers and Sisters. We're the only chapter of a national organization called the Sibling Leadership Network, where there's a resource for brothers and sisters that have sibling disabilities. I highly encourage you to learn more about us. Certainly, if you have parents in the room, in the virtual room here, certainly talk to your other kids about. There is this stuff out there. There's so sibsnetwork.org is a state website. Sibleadership.org is a national organization. You're there as a resource. There's more information about that. If you go under our handouts, check the box for more information about and see more information about siblings. So you go remember an intro screen about going and clicking that link. You'll be able to access through that the information about siblings and things called sib shops for younger siblings. If you haven't heard of them yet, different nonprofit organizations, school districts, and all different types of entities will run these fun social activities for brothers and sisters that will be each targeted to 7 and 8-year-olds, 9 and 10-year-olds, 11 and 12-year-olds. It's become an international phenomenon, the idea of a sib shop and being able to meet their peers and live some life experiences. And there's also the adult siblings. So we do bar nights and barbecues and all kinds of other stuff. And people post on our Facebook page, which I know some Gen Zers now are joining Facebook, and who knows what the future is with that. But people post about they're getting married, they're this thought or concern, or they're really battling how do I deal with this issue. My brother has major behavioral issues, and my wedding, he had a one-on-one aid with him, so that my parents could be my parents at my wedding, and he could have the support he needs. And when he was kind of had enough, and he's done, they could take him up to the hotel room upstairs and have him have a break or whatnot. And trying to give other siblings ideas of how other people have handled it, and also being there to support and validate what their feelings, emotions, and decisions they may make about. Some people said, I just don't want my sibling there because of the nature of their challenges, they're going to be a huge distraction. And I want to just have one day in my life where that's not that. And we are there to validate that. It's a very real feeling and emotion. At the same time, obviously they probably also feel guilt about it, and we're there to be there as a support network. There's a lot of parent support groups out there. There's not really that much up with siblings, and siblings do need that. So having said all that, when we get to the general concept of planning for the future, one of the first questions people will ask is, how much does someone with XYZ disabilities, challenges, needs, how much do they need in terms of financially, how much do they need for the rest of their life? And where is that money going to come from? Where are the resources going to come from? Okay. The big 30,000 foot overview is that government benefits is our base. Right? It's the widest part. So we want to make sure that we have all the benefits and services that the government will potentially provide, and can be a very significant expense they're paying for. That's our base. And Social Security, and talk about Medicaid, Medicare, all this stuff. That's our base. But inheritances is the reserve fund over and above those government benefits. In order to make it be a reserve fund, we need a special needs trust, because if we don't, we lose the government benefits. So the answer is special needs trust. And as you see there are actually 2 kinds of special needs trusts, which is a little confusing, because two kinds. And if you look on, if you Google special needs trust, you'll see references to both types of trust interchangeably and not differentiating the 2 different kinds of trust. So we really do want to make sure that we understand there are 2 kinds of special needs trusts, and they're very different. And we'll talk about that. And they can still work and make some money. Many of our clients work to some extent. My brother even works in the community with a job coach. Half the time the job coach does a job he watches. Other times he participates a little bit more. He's not earning a lot of money there, but he is absolutely working in the community getting out there, all of that. So as long as it doesn't earn too much money, it doesn't affect his benefit. So there are these resources such as asset limits for the basic, the most important government benefit programs. So we need to kind of get into why it's supposed to be so important, and it is these government benefits. So let's talk about SSI first. SSI is Social Security for someone who doesn't have a work record, effectively. And they have a $2,000 asset test. And that asset test has not changed since the 1970s. It's been $2,000, no inflation adjustment, nothing like that. And so that's pretty crazy that there's still at $2,000. But there was proposals every few years to change that. It's not going anywhere anytime soon. So $2,000 asset test. And that's do they have one $2,000 name? Because that's the first threshold test. If you would apply for SSI for for a child with disabilities, the first thing to see is, do they have one $2,000 name? And when they're under the age of 18, actually, the first day of the calendar month after 18 is when they stop looking at it. Before that, even their birth month, the month in which they turn 18, they still look at parents' assets and income. It's not until the first month after they're 18 that they actually stop looking at parents' assets and income. They will look at the parents' assets and income again until then. And then after the first day of the calendar month, after a child turns 18, they will begin to only look at that child's assets and income. So again, assets pretty straightforward and clear. Can have more than $2,000 in the name. There's one additional piece of this, which is a 3-year look back period, which is that when you apply for SSI, they go back 3 years to what's in that child's name in the last 3 years. So if they're 18 now, the first month after 18, they don't, parents, doesn't matter if they're multimillionaires, it's irrelevant. It's about the child's assets and income. However, when they look at the assets, they do look back 3 years. So if the parents had accidentally or forgot, didn't know, and there was a custodial account, a UTMA account, a savings bonds, a joint account, whatever it was, in the name of that child, the SSI will know about it. They'll see it in the records because they go to the IRS computers and look at some security numbers, and they will count that against them for the last 3 years. So they will say what happened to that money, and if it wasn't spent for their benefit in a way that SSI approves of, they will count it against them. So it's another piece to know about. Now, the $2,000 asset test, that's the easy part because it's pretty straightforward. You have 2,000 in your name, you have more than it. In the last 3 years, more than 2,000. What happened to that money? For most people, we can figure it out. If it turns out that they are within the look back period, well over 2,000, there's different tools we can use to exempt that money. The most important one we'll talk about later, called enable accounts. But that's an easy solve no matter what's going on. And in many cases, the parents have been hurt, have been educated enough that not to put money in the kid's name, that there is no money. Okay, so then we go to the disability test, which is the income test. Do they have the ability to earn in today's dollars? It was $1,350 a month this year. After January 1st, it'll be $1,470 a month. That is a gross work earnings in a single month number. Okay, so what they want to say is it's called substantial gainful activity, or SGA. Does the individual have the ability to earn in today's dollars after January 1st $1,470 gross work earnings in a month? Now, if they do have the inability to earn that amount of money because of their disability, then and they will look to, there's a whole list of things they look at in terms of do they have a listing level impairment, what assets they have, or what's the nature of the disability, and then they go to an autism, for example, is a listing level impairment. Some other disabilities are not, like Down syndrome, surprisingly not a listing level impairment. Then we'll go to things like an IQ score. If the IQ score is below 70, then they automatically qualify under a threshold intellectual disability definition. And that gets them through the first part of the two-part test. The second part is the more complicated part, which is, do they have the ability to earn that 1470 gross earnings a month, which they look at is substantial functional limitations, nature of activities. They look at concentration, pace, persistence, appropriate social functioning, all kinds of aspects that would go into why they couldn't earn their money. Now, assuming that the child, adult at this point, with disabilities does get through these two tests, and they owe us $2,000, it's clearly they can't earn more than 1470 gross earnings in a month, which for many people, the application, they approve it based on just the IEP, school records, medical records, etc. For many others, they have to sometimes hire an advocate to help make sure that they are making the case the best way possible. And then for many others, they have to hire a social security disability attorney to actually go through the appeals process to win the case later. So those are kind of different paths people take to getting it. But once they get through that process, they get a check from SSI for next year. The number is $914 a month. Okay. Now, that 914 amount can be reduced if the parents are not charging them rent to live at home, for example. They'll reduce it by a third. So there's all kinds of rules with that. If they're working and they're not in the school system anymore, they're beyond the transition years from transition program from school, then they actually have to, the work earnings will reduce their SSI after $85 a month. So there's all kinds of rules about how SSI gets reduced, but SSI is not the most important program up here. It may be, in fact, the least important program up here in the long run. But the reason why we start with it is because if you don't get SSI shortly after the child turns 18, the rest of this rule becomes much more difficult to get. So we want to start there because it opens up a lot of doors. One of the doors it opens up is what they call SSDI, Social Security Disability Insurance. Okay, that is Social Security for someone who either has a work record and is disabled, or becomes disabled, or had or on a parent's record. They call that CDB or DAC status, civil child or childhood disability benefit status. Okay. Now SSDI does not care about the child's assets. Okay. They could have $1 million in their name, a custodial account, whatever. They would still qualify. The problem is they would never qualify for SSI, which is the easiest way to qualify for the CDB benefit or DAC status. So the way it works is this. As long as the individual disabilities receives SSI before 22, then when a parent takes Social Security retirement, disability, or passes away, so retires, they get to go on their parent's Social Security record and get more money. The amount they get is based on what the parent has paid in the system, and so it would be very substantial. Say it's like a doctor or accountant, a highly paid professional of some sort. Their Social Security record is very substantial, and therefore the child's Social Security record on the Social Security DAC benefit or CDB benefit on the parent's record is actually $1,800, $1,700, sometimes $2,000 a month or more. It's the amount they would be collecting. Again, this is not until the parent takes Social Security retirement, God, who became disabled or passed on. So hopefully get just retired. So this could be many years after they get SSI, but we got to get an SSI before 22 to open up the door to get that SSDI DAC CDB benefit down the road. Now, if they get Social Security, and there's another way to get it that I don't want to belabor, where it's if they're, they can build their own quarters, and if they have SSI already, they automatically get SSDI once they have enough quarters. Special rules if they're under 24, how to get it. I can answer questions, question time if need be. But one of the key things that once they get SSDI, whether they get on their own work record, and we can get into that for any parents or professionals in the room that want to talk about it at the end here. But when it comes to this DAC or CDB benefit status, which is the way my brother got Social Security, didn't get on his own work history, but on my father's when he took Social Security retirement, they get Medicare 2 years later. Either way they get Social Security, Medicare comes along 2 years later. It's a 24-month clock to Medicare. Pretty big deal because Medicare is pretty good health insurance to have, and we like to have it in our back pocket. Because one of the things we talk about a lot is we do not want, Medicaid we'll talk about in a second, it's the last quadrant up here, and that one is the most important program up here by far. However, I really try not to have Medicaid become the primary health insurance for individual disabilities. I really try to have the private health insurance or Medicare or both be ahead of Medicaid. And Medicaid always be a secondary or third level of insurance, not the primary. Because Medicaid is not, fortunately, not the greatest access to. Most doctors don't take Medicaid. A lot of therapists, specialists, etc., do not take Medicaid. So if we want to make sure that all the available resources we want for them are open, we want to try to make sure we at least have Medicare or private health insurance ahead of Medicaid. So again, Medicare having it, whether it's after 2 years after they get their own Social Security record built up, or maybe in more cases, there's a parent's record and the parent takes to retirement, they get Medicare 2 years later. But that means they're also getting Medicare, sometime between their 20s and their early 40s in most cases, way before 65. That's a pretty good thing. All right. Now, when it comes to Medicaid, there's different rules for the different types of Medicaid. Okay? It used to be more simple, but it's become more complicated over the years with the Affordable Care Act, Obamacare. They have this expanded Medicaid concept where they have no asset test, but they have this kind of strange income test, which is about $1,600 a month, but it's a modified adjusted gross income amount based on tax returns, and it actually counts the parent's income even after 18 if the parent's child is dependent on their tax returns. Very strange rules, very different than traditional Medicaid rules, but they are allowed to have unlimited assets technically, although they couldn't have basic taxable income effectively with 1588. So if it was invested any significant amount of assets, they wouldn't qualify anyways. And if they have Medicare, they also don't qualify for the Affordable Care Act. So if the parents then is independent, the parents have any sort of substantial income or assets and any normal average typical amount, they don't qualify. Child doesn't qualify. If the child has Medicare, they don't qualify for Affordable Care Act Medicaid. So it is not that useful for that many years for many people with disabilities. The traditional Medicaid, it's referred to as Aid for the Aged, Blind, and Disabled, AABD Medicaid. That one has been around for a very long time, and that is that $2,000 asset that SSI has. So special needs trusts are very important for Medicaid as well as SSI. And it also has an income test sorted. It's called an income spend down. We can usually get around it in different ways. Social Security on a parent's record, the CDB benefit would be $2,000 a month. And by the way, when the parents pass on, the amount the child gets is worth calculation of 75% of the parent's primary insurance amount. They're a full retirement age Social Security check amount before any Medicare premiums taken out and all that. It could be $3,000 a month. Okay, so that's way more than $1,158. The good news is Medicaid as a rule, they don't count that benefit in almost all cases. There's a rare circumstance where they do, but in the vast majority of cases, they don't count that against the income spend down. So this is irrelevant for that Social Security benefit. It's more just about income, and most people don't have that much income because they would lose their eligibility for Social Security if they get too high and close to that 1470. There is a Medicaid buy-in program called HBWD, Health Benefits for Workers with Disabilities. You can maintain Medicaid eligibility while they're working and have a higher asset. That's $25,000. They also allow retirement accounts to be exempted, but it isn't as useful as it would appear because eventually they will, if they keep earning more money, and they're going to eventually probably lose their Social Security, disability determination, disability, and then HWD kind of falls away too. And so it's a temporary thing that can help for a little bit. ABLE accounts are more useful. We talk about the asset test exemption, getting rid of money, or trying to get around the $2,000 asset test. But Medicaid is so crucial because it's much more than medical. It's what pays for group homes, day programs, job corps, support employment, something called home-based support services or in-home family SILA. These are all different types of programs depending on the level of support needs the individual has. If you need 24/7 group home funding, you need more medical, higher level medical need. You need round the clock nursing, at least on call. Whatever level of support they need, Medicaid is funding all of that. And the cost of that care is, for someone, for example, with intellectual development disabilities, would range from at minimum about $33,000 a year, called the Home-Based Support Services Program, all the way through to over $200,000 a year for someone with medical needs. My brother, his rate, he has no, I think, on medical needs, but his behaviors and the nature of his disability, he needs 24/7 one-on-one support. His rate's about $140,000 per year. So these are astronomical sums that even very affluent families cannot afford to private pay for 40 years, 50 years, 60 years. So we want to make sure that, of course, the special needs trust is there for inheritances to not affect eligibility for that Medicaid that's going to pay that very significant, almost unimaginable cost, and then have the trust be that reserve fund to supplement that. And we can talk about that as we go on. Now, health insurance is an important thing to talk about because Illinois is unique. And this is the one thing that I get to brag about at national conferences. Generally, coming from Illinois, my colleagues, the national board of directors of Special Needs Alliance Group, we just had our first in-person meeting in 3 years. And we're hybrid, basically the first in-person meeting in 3 years. And basically, everyone, people coming from New York or California or Washington, or they have really great services. Massachusetts, all these places, they have great services. They have great programs, and really wonderful funding, crazy amounts of money. Our rates, my brother's $140,000 rate, that's like an average rate in some states, and not a super enhanced rate because of behaviors. We end up talking about subsidizing the rate effectively because Medicaid rates aren't sufficient to cover the support staff 24/7, and certainly not one-on-one. And certainly not with the pay increase we need to provide in order for staff to stay and not leave with the current workforce crisis. So, other states are paying their staff 50%, 75% more than we're paying ours. which is pretty crazy. And they're just it's a lot easier to get a higher level of support needs met. But that said, okay, great. Illinois is not good on that stuff, and we'll talk about how we're getting better with it, and not because of our politicians being any better, but it's actually because of lawsuits that we were sued and lost. But we have a law that is really good, and no one else has this. Massachusetts, Vermont, all these places that are so good for services and funding, they don't have any law like this. When a child turns 26 in Massachusetts or California or all these places, they lose their private health insurance, their parents' dependent health insurance, and parents employer group health plan, and they become Medicaid. Medicaid becomes their primary health insurance. That's obviously not a great situation, and that's what happens in virtually every state other than Illinois. Illinois has a law that's been around for a very long time that for some reason we snuck in there many years ago, and it's been amended positively to make it even more accessible. That says that basically a child with disabilities, unlike every other child in Illinois, can stay on a parent's health insurance past age 26. This is a very big deal. There is no limiting age. 26 is not a limitation if they're disabled. And this is the language they're using handicaps. Old language they're still using in the statute, but they still have it there. Basically, they say it's incapable of self-sustaining employment, all this other language. The point of it is that if they're getting SSI or SSDI, they by default qualify for this law to protect their eligibility for being independent on their parents' health insurance plan after the age of 26. Now, a couple quick notes when it comes to self-insured plans. They don't have to follow this law because they're self-insured. It's a large corporation where they take on the risk. There's a big medical expense. They still will use like Blue Cross, Humana, United Healthcare, or what have you, as the administrator of their plan, but they actually take on the risk, and therefore it's not a traditional health insurance plan, and so they actually are exempted from this law. Having said that, every large corporation in Illinois that is they're all self-insured at this point, they've all followed this law. Maybe because it's the default provision, and when they can just accept as the self-insured plan, they accept a lot of the default provisions of the health insurance company uses for other plans in Illinois. So maybe it's that, but some of it maybe just it's a small thing, and it helps a few families. It's not that expensive in the scheme of things when you have thousands of employees. That's the right thing to do. The only self-insured health plan I've ever seen not follow this law, fight us on this, is the state of Illinois. So every other private employer in Illinois, even the ones that don't have to, these big bad corporations are following it and doing the right thing, whether it's just because they did it without thinking or because intentionally. But Illinois is intentionally not. They're intentionally trying to not allow these children with disabilities to stay on the parents' health plan. Professors in the University of Illinois have had a number that have been trying to, we had to fight and call state legislators, state reps, state senators. And then once they had enough people in Springfield calling the state agencies that are dealing with the health insurance plan, they said, oh, okay, yeah, fine, we'll exempt your one child, we'll let them stay on past 26, but this is not a rule. We're not making this for everyone. So anyways, that's just a little underscore of that one. So that information request form, again, there's this one of the things you can get, and go to that link, again, go on our website, go to the schedule of the calendar of events, go to tonight's event, you'll see the links to the stuff in the information request form to get more information. You check the box with that item number 4 and get more information on this health insurance situation. Okay, now we know we can't leave money directly to an individual who is disabled. That use their eligibility for benefits, services. They probably could not handle their own money. So in many cases, there's a lot of reasons we, of course, would never want to leave that money directly, wise. And if someone in Illinois does not have a will, the law is written for you. It says half goes to your spouse if you're married, and half goes to the kids. And if you are not married, or if you're not married, then all goes to the kids. And if you visit your name alone, you're going to be or join tenants name beneficiary. Then when the survivor passes, that's when it would become a big problem. So the next thing people used to do is they would say, all right, we're going to disinherit them and leave everything to the other kids or an aunt or uncle or someone else to be as a moral obligation to use it for their benefit. Well, that doesn't work, right? Because they're not going to be able to for sure protect that money, because even if they're the most honest, trustworthy, financially sound person in the world, and in that regard, the money's not going to be at risk. They could have some unrecognized IRS creditor problem that comes up, and a divorce, the ex-spouse can go after their assets, and now that money's at risk. So we don't want to do that. It's a moral obligation, not something we want to do if we can avoid. And traditional trust people use for the basic support of an individual work just fine for younger children that we want to make sure until they're maybe in their 30s that aunt or uncle watches their money in case the parents were to pass away prematurely, God forbid. That's fine until the older ages. That does not work for someone who's going to be on government benefits. So for people who are on government benefits, we need what they call, again, a special needs trust. Okay. So special needs trust, there's two kinds of special needs trusts, as I said before. A third-party trust for gifts and inheritances, and then the first party self-settled over a D4A payback trust. There are a lot of different names for that kind of trust, okay? It's not as friendly, and it's confusing because, again, they are referred to interchangeably, but they are very, very different. Okay. So, when we say the special needs trust, what they have in common are reserve funds over and above government benefits. There is no limit how much money can be in a special needs trust. There could be millions of dollars in a third-party special needs trust, or obviously a first-party self-settled trust, and it doesn't impact government benefits at all. So third-party trusts been around for a long time, the early 80s by court decision, 91 by Illinois statutes, and it was updated in 2020 with the Illinois Trust Code. But it's important to remember that gifts and inheritances can go in here, but not first-party money. The child's money can never go in here. So again, inheritances, gifts from mom, dad, grandma, grandpa, aunt, uncle, life insurance, retirement account, beneficial designations. And by the way, retirement accounts under the Secure Act and proposed regulations, as well as a cleanup bill going through Congress, people call it Secure Act 2.0, that has been passed by both House and Senate, but the conference bill has not been passed yet. The hope is in the lame duck session it will. It is bipartisan. But that actually is really important when we look at the special needs trust, which says that it protects special needs even more so. But even in the original Secure Act, most special needs trusts are protected from the stretch rules were changed. So basically this idea of when someone retires, they have requirement distributions every year. They take the money out of the IRA by a certain amount based on life expectancy, so that they pay taxes on the requirement distributions after 72. That concept exists for inherited IRAs and always did, but it used to be they would be able to stretch it. An individual would be able to stretch it over their life expectancy. They changed the rule in 2020 and they said, no, individuals can only stretch for 10 years. They have 10 years to stretch it out. After the 10 years are up, they're done. So if there's $1 million retirement account they inherited, they're going to have $100,000 ordinary income added to their tax bill every year for those 10 years and pay taxes on that money. But there is an exception that applies here, which is that if the money's inherited by a special needs trust, then it gets to qualify for the lifetime stretch still, based on the child's life expectancy, which is based on standard life tables, regardless of the disability. But there's some other nuances about what if there's a charity that's a contingent beneficiary, it could mess things up. The law that hopefully will pass, that's passed both House and Senate, but needs to pass the conference bill, needs to pass and be signed by the president. That would clean it up so that there is no issue on charities, even if there's a charitable, beneficiary, which often there is. They want to leave, parents want to leave something to the agency that provides services to their child during their lifetime, that it will not mess up the stretch. The child's special interest will still be able to stretch out those requirement distributions for 40 years, whatever life expectancy is the time of the second parent's passing. And that's a big deal because it really reduces that tax liability substantially. But the key thing to remember is this bottom thing that I keep mentioning this because it happens constantly, which is the beneficiary's own assets cannot go into this trust. So there's no way about child support too, adult child support payments, another topic of discussion, but that can't go into this trust. The individual's custodial account, savings account, social security money that's going over $2,000, work earnings, I don't care what it is, it cannot go in this trust. Okay. It's such a common thing that people do. They immediately think, wait, I can't go over $2,000 in their name. I'm going to move it in the special interest. Don't do it. It's one of the biggest mistakes people make. This trust can only receive money from third parties. If the child's money is in here, it can potentially taint the entire trust to make it all a resource and they lose all their benefits. Don't do it. I don't know how many times I can tell people don't do it. Still do it. Do not put the child's money in here. I don't care what social security, work earnings, and inheritance that was incorrectly left directly to them. I don't care what it is. Do not put it in this trust. Only third parties directly put money in here. Now, when the child passes, you get to decide where it goes as mom and dad or grandma, whoever sets up this trust, oftentimes it's mom and dad, they get to decide where it goes. All right, so could be oftentimes it's the other kids or grandchildren, siblings aren't alive with that child disabilities. It may be charities. It may be the guardians who acted proportionally, however long they acted. Thank them for the work they did and the time that they spent. And if they're not alive, their kids wouldn't benefit from that because it affected them. If the parent was doing that job, there's all kinds of things depending on obviously the situation for that child who's in the family dynamics. But the parents, whoever sets it up, and usually the vast majority of the time the parents are doing it, they get to decide where it goes. The government has nothing to do with it. There's no payback to the state or anything like that. It's what we see very different than the other kind of trust. So the special needs trust, we do not want to be inside of the parents' will or their revocable living trust. We actually want it to be a separate, freestanding document because we, for a lot of reasons, okay? So we don't want it to be inside the parents' estate plan, their will, or revocable living trust. We want it to exist, now, okay? Because if we have it inside the parents' estate plan, we would not be able to do something we like to call piggyback, which is that grandma, grandpa, aunt, or uncle, especially if they don't have their own children, they want to give something contingently or directly to that special interest when they pass. We want to make sure that it's going to the trust will exist. They can actually name it. If the trust won't exist till both parents die, which is how it would work inside of an estate plan, and if it's their living trust or will, there's nowhere to name. There is no trust to name. So we want it to exist for that purpose. We also want to exist for grandfathering purposes. If laws or rules change, they usually grandfather existing laws, existing trusts. So we need the trust to exist if we want to be grandfathered, even if they change the laws or rules of this. If grandma or grandpa or mom or dad needed skilled nursing care, God forbid, they needed that level of support themselves. One of the biggest fears a lot of our parents have is they worked very hard, they saved, they invested, they have an estate, and that was not easy to accumulate of a couple $1 million. And they are really worried that if they need skilled nursing care, it's going to wipe out all of that hard work. Not because it's 50. The inflation we're seeing now, it's often over 15,000 a month. And if you're talking about memory care, dementia, God forbid, Alzheimer's, you give out 20,000 a month. I mean, very, very eye-watering sums. That amount, 240,000 a year, or 180, 240,000 a year, somewhere in that range, that can wipe out a very substantial estate in a matter of years. And if the so that's a big problem and a big concern that a lot of families have, and they have long-term care insurance, all the kinds of things. They try to offset that concern or give them some peace of mind. There is actually a federal law that helps families with child with disabilities, and that is they can choose to transfer their assets to the special needs trust. So normally the rule is if you try to give your money away, and have the state pay for your skilled nursing care, they will penalize you for 5 years. They will not let you get Medicaid for 5 years. It's a big mess if they do that. It's the worst case scenario. But there is a federal exception to this 5-year look back rule, which is if you give the money to a special needs trust, it's what they consider a permitted transfer, which means there is no look back. They can gift it. Mom, dad, grandma, grandpa can gift their estate, their assets, deed their house, transfer every asset they own into the special needs trust, get themselves below $2,000 in assets, and have Medicaid begin to pick up the cost of their skilled nursing care and not have to spend down everything else on that huge monthly cost. So that is something that's really important for families to know, is that there is a way to protect assets if we're worried about spending it all down until there's no money left. Okay. All right. Now, when it comes to gifts, if grandma or grandpa or aunt or uncle are giving a birthday present, if it's a check and they're going to spend it next week, I don't care about it that much. But if it's a larger sum of money or something for the future, they should maybe consider writing it to the third-party special needs trust. Well, the trust would have to exist for that purpose. There is an exception to that, which we'll get into later about for people with very large estates if they're trying to get gifts and some tax rules. All right, you say, all right, I know what a will is. I die, what happens to my assets? What about this trust concept we keep talking about? All right, it's another way of holding title ownership to assets. So just like an individual can have a brokerage account with the stocks, mutual funds, and other investments, it could have a savings account, a checking account. An individual can have own real estate. It can own an inherited IRA. So can the trust own all of those types of assets. So the trust is not an account at a bank. It's an entity. It's like a business that can own all types of assets. It can own accounts at several banks, brokerage accounts, investment accounts. Again, every type of asset under the sun, the trust could own, including inherited IRAs with special tax beneficial rules. Now, third-party special needs trust, the paperwork, see the structure, and the rules of the road. There's an account, there's an investment, name of the special trust, who's in charge of it, and what happens when the parents pass on, when the child passes on, how can the trust be used during their lifetime? And the fact is that anyone can put money in this trust except for the beneficiary. I just keep emphasizing this because we've been talking about it for now. My father's started doing special needs planning and trust in the 80s, and we still every month at least some client, no matter how many times you tell them, calls us that they messed this up and they put money in the special needs trust. That was the child's money, so just don't do it. All right. Now, what you do in terms of planning for the future is really, really important. But other people can mess this up too, right? And that's why we need to get the word out to the extended family, especially grandparents. And if there's an aunt or uncle out there, or a great aunt or uncle that does not have children, they are the most common sources of this of creating some big mess with government benefits. Again, intentionally or unintentionally, doesn't matter. We need to make sure that they don't accidentally or purposely leave money directly to the child who's getting benefits or in a trust that's not a good special needs trust. So how do we do that? In our firm, we suggest people do is have an instruction letter. Dear extended families, this is something we do for our clients. Any attorney that's doing this should do it. Dear extended family, you want to leave or gift money to the special trust. Here's the language that you need to put in your trust or your will to make sure it doesn't go directly to them or any other sort of trust, but to the special trust their parents set up for them. And here's a fill-in-the-blank form, grandma, grandpa, aunt, uncle, that adds a paragraph onto your will. A codicil is a fancy word for an amendment to will, or an amendment to the revocable living trust that says if something happened, or if something occurred where the child with disability is going to receive money, or some trust for their benefit will receive money, whether it's again their direct beneficiary or contingent beneficiary if certain people are alive, it covers the situation that just in case it would ever get there, it does not go to that child directly. It goes to that special needs trust the parents set up. All right, so one of the issues we run into a little too often, unfortunately, is a uninvolved or just kind of a non-absentee, whatever you want to call it, parent, grandparents that they're in the event of a divorce are not so involved in the child's life. So we have something called the ex-spouse letter that my father used to kind of jokingly call the Dear Jerk letter. And basically what it says is like, we're not getting into all the stuff you were fighting about, they were fighting about all that with divorce. All this letter is telling you is do not leave money directly to that child, leave it to a special needs trust, create your own if you want, piggyback on mine, I don't care. But you don't want to leave money directly to them. It's going to be a big mess for the benefits. All right. So that's the important thing, making sure that we don't have the ex-spouse situation potentially. Now, so we have to set up special interests. We have to reference it in the estate plan documents. We have to get the extended family on board, but we cannot forget to change beneficiaries because there's life insurance policies out there. There's retirement accounts, and there's maybe a rollover IRA from another job that parents had, and there's a 401k from the current job. There's all these different things out there. We have to make sure we don't miss anything because unfortunately I've seen it happen where something gets missed, whether it's a life insurance policy or retirement accounts out there. And even though they have a special interest, even though they have their estate plan in place, and even though they did all that, because that one beneficiary was not updated, the child's going to get $100,000, $50,000 directly, and now we have a big mess on our hands to try to clean up to try and get their benefits reinstated. So be careful about beneficiaries because they bypass the wills unless they follow the will, follow the revocable living trust. When we get to gifts, again, if it's a birthday present, whatever it might be, that's fine. The holiday present's fine. What I'm more worried about is larger gifts. Now, if it's a few $100s and it's from someone who is not extremely wealthy, they can probably make a check written out at the special needs trust. We're fine. Even if it's someone, it's a grandparent and they have, a couple $1 million, but they want to make a gift and it's $1,000, that's fine too. The issue would become if a grandparent or other relative who's making these gifts is trying to utilize the annual gift tax exclusion route, which at this point only applies to a very small percentage of people. because it was way back when it was 10,000. That's what people think of it as, but it's been adjusted for inflation over the years. And as of January 1st, it'll be $17,000 per person per year, which if it's grandma and grandpa together give 34,000 and all that. The problem is that that rule does not apply to special needs trust because it's a future interest gift. A lot of technical stuff there. But the point of it is that we cannot, those situations are where we cannot give to the special needs trust because it will not qualify for the tax benefit. So that's when we have to have a longer discussion of different ways, different tools, and different manner in which we can make those gifts to avoid this future interest gift issue at the same time not affecting the government benefit. So that is something to be aware of. It doesn't apply, of course, to vast majority of people. Even the Illinois state tax, which doesn't even have a gift tax component to it, that's $4 million exemption for federal. It's kind of new. It's the new number is about 13 million. It doesn't affect most people. All right. Now, so far I talked about the third party special needs trust, but what about if there is money in their name? Okay, so maybe there are savings bonds from when they were born, and maybe they had a retirement account that they of their own, or Social Security. There was a custodial account that was in their name, or under Illinois law, usually we can get away with it until 21, and then it becomes a problem. Some states not, but usually Illinois, that's fine. Some Social Security offices will accept that, and they give us a hard time. We've been 18. Again, an inheritance or gift incorrectly left directly to the child. Child support post-divorce, an adult child support payment post-18, which can be court ordered. That also would be potentially a situation we're dealing with here with what they call first party money. Access to security, again, there's all these different pieces to it. A lawsuit settlement. All right, so if there's a medical malpractice, personal injury settlement, this could be from birth. When people do it shortly after birth. We've had clients where it was 10 years later, 15 years later, the child's got a teenager and they never pursued the case. It's actually a special Illinois statute that tolls the statute of limitations beyond all the way indefinitely if they have a cognitive disability. So we've had clients who at 15 years old pursued a case and so from when they were born and won multi-million-dollar lawsuits. And those kind of situations, those assets, depending on how it's structured, it oftentimes has to go to a different kind of trust because it is money that technically belongs to the child. And we need to get them to qualify for benefits. So we have to do something with it. If it's whatever this amount of money is, wherever it comes from, if it's a few $1,000s. Oh, just one other thing. 529 plans do not count against them for assets with one small exception, which is if some reason a financial planner set up that 529 plan, put it in the child's name, then that's a problem. But that is a very rare circumstance. It was financial planners trying to be too clever and trying to take advantage of some weird FAFSA rules with when you apply for student aid, grants, all that. That's not, but it makes a big mess of benefits. So in most cases, the parents own the 529, the child's a beneficiary, therefore it's not an asset of the child's. All right. So again, if it's a small amount of money, it's in their name, the custodial account when they're turning 18, you could spend on things they need anyways, including the special needs trust, cost itself, for example, establish that. But what if it's a little more money? Okay, we can use ABLE accounts in a lot of cases. So it's, every basically 40 some odd states have their own ABLE program now. It was modeled after the 529 college savings plans, just like those plans, each state kind of creates their own plan, has their own rules about it. But the basic federal rules are that there's a $17,000, and this went up, as of January 1st of this coming year, total that can be contributed from all sources. So it's weird. It's tied to the gift tax exclusion, but it's actually a total amount. It's not per person. So that makes no sense. But for whatever reason, that's what they did. So you cannot contribute to an ABLE account in a calendar year, anyone total from all sources, more than $17,000. So if one person put $10,000 in there, it's only $7,000 left for anyone in the world, including the child, to put more that money into. The ABLE account, the cap is cumulative from all sources. Now, you can only have one account per beneficiary, so you can get around that rule that way. And when the child turns 18, they become the owner of that account if there's no guardianship. If there's no guardian, different. The balance cannot go over 100,000 or they will be suspended from SSI. And it can never go over the 529 maximum in that state. So in Illinois, for example, it's $450,000 cap. Now remember, go back to this one, $17,000 annual cap. How are you getting to these numbers of 100,000, 450? Not very quickly. And here's the thing: the limitation on how to spend it used to be one of our bigger concerns about ABLE accounts, but over the last few years, the IRS came out with those regulations and said, we don't care how you spend the money. This is using obviously layman's terms here. We don't care how you spend the money as long as it's for their benefit. We don't care. we're not going to assess penalties or taxes on you for spending the able account on whatever you want, vacations or whatever frivolous things. I don't care. Even if it's not a disability expense, which is what the statute describes. It also says the IRS gets to decide final say on what is a disability expense, and they define it as whatever the heck you want to spend it on, as long as it's for their benefit to other people. But here is the reason why the bigger concern I have with able accounts is the potential payback to the state. So here's the thing. The federal law says that the state can enforce payback for what Medicaid is paid during their lifetime, which is often hundreds of thousands, or in my brother's case, millions and millions of dollars, which means that it would wipe out whatever's in the able account when he dies. Okay, so that's the payback concept. Beware of Illinois' rule, because Illinois basically said, okay, you said the state may enforce it, so we're not going to enforce it. The problem is that CMS, Center for Medicaid and Medicaid Services, they have promulgated regulations that say that states don't have a free hand. They have to enforce the payback for long-term support services, including home funding and waiver services and all that. The stuff that costs big dollars, the state has to enforce the payback. Otherwise, they're not eligible for the 50% match the federal government pays. Well, guess what? Illinois is taking up its proverbial middle finger, saying, hey, we don't care about what you said, federal government. We're going to ignore it. Well, there's something called the Supremacy Clause in the U.S. Constitution, which says the Illinois cannot ignore the federal government. The scary part is that Illinois at some point this may come to a head, and probably not under a Democratic president, but maybe under a Republican president, where there may be an issue. So I always tell families, do not expect that the refusal to enforce payback to always be there. I think that unless we get the federal law changed, that it is very likely at some point Illinois is going to have a big mess in their hands and going to have to be basically at the threat of being bankrupt. Effectively, they're going to have to start enforcing the payback provision that Medicaid requires. So don't expect the payback to always be not enforced like it currently. And because of that, I don't want my grandparents or other people or mom and dad putting money in there every year. This is not a great place, like a 529 plan where, oh, we're safe for the future. That was one of the ideas of it when it was passed. Because of the payback, it's not really that great of a tool for them. It does grow tax rates on the able account, but if there's a payback when they die, who is the real beneficiary of that? The state of Illinois. All right. If there's no guardian, again, remember they own it. If they're a minor, then the parents are in charge until the child turns 18. All right. Now, when do we like to consider able accounts? Social Security, is now, they're getting a lot of Social Security maybe on a parent's record. They've switched to the parent's record, the DAC or CDB benefit when the parent took Social Security retirement. They're getting $2,000 a month. The parents passed on, they're getting $3,000 a month. They're working and making $800 a month part-time. And they're really quickly going over $2,000 every single month, and they can't spend it fast enough. Well, maybe we transfer to the able account the excess and keep it under $2,000, and that could be a useful way that we use an able account. There is the HPWD idea, but honestly, I think at this point, I used to like it should be better. I think at this point, I've switched over to saying able accounts are probably our best option in those situations. Short-term savings accounts, basically the idea of trying to teach someone who is a little more independent and able to really understand these concepts. It might be nice to say, hey, you can save some of your Social Security or work earnings in this able account and figure out something you want to spend on it later. Kind of teach them this idea of saving for the future, right? Saving for big purchases. Also, we've had situations where the individual is very, fairly independent. Maybe they only have physical disabilities, but are so substantial they need all these benefits and services, like CP is one of the big ones, or cerebral palsy. Then maybe we'll have the special interest distribute money to the able account to give them control over spending money, because you can't have a special interest distribute directly to an individual, no matter how if they have capacity or not. You can't do that; they'll lose their benefits. It's you're going to get income then, basically, for Medicaid rules. But we could distribute to an able account, which is then completely exempt. There is a rule with that 1/3 reduction with SSI. You go from 914 to reduced to like 600 by a third. If you don't charge rent or fair share of expenses to the child who's living with mom and dad, there's a whole thing. If you charge fair share, it's over the 914 amount. If it's an expensive house, then you can have a situation where they would lose it no matter what. There's a way using able accounts to get around that rule. It also comes into play with individuals who are more dependent. They're renting a place that's way more than 914 a month, and the parents are subsidizing it. There's a way to use able accounts to do the subsidy without reducing SSI. Small inheritances, not quite left with third-party trust. Also, $10,000 to each grandchild. Able accounts can come into play there. Small lawsuit settlements are part of a class action lawsuit that can come into play. Also, if they are getting HUD funding, the Section 8 housing vouchers, there's a number of individuals that are receiving those that funding. Able accounts are exempt, unlike special needs trusts they're mostly exempt, but there's some situations where we can run into problems. With able accounts, there is no problem. It can go as extreme as the able account can pay the rent that is being subsidized, which is the one thing you can never do. No third party can pay the rent for someone who's getting subsidized housing, because otherwise they'd say that you don't qualify. Able accounts are the one thing that's exempt. They can even pay the rent, and it would not disqualify. It would reduce the subsidy from HUD for the Section 8 housing voucher. But that's kind of, again, another situation. Here's another thing: divorce situation, the child support court order. It used to be you had to always open a first party special needs trust, establish one, and open an account and have child support court order directly into a first party special needs trust. That's no longer the case if it's a smaller amount of child support. If the annual child support is less than the annual able account total, a cap of 17,000 next year, you're able to then put it into the able account at the court order, the able account, and not the special needs trust. Now, this rule is really crazy because the POM, Social Security's internal rules, are pretty clear you can't do this. But the Chicago region of Social Security, which covers not just Illinois, but a lot of the Midwestern states, they said you can. So they say you can, fine. So SSI says you can, Medicaid will go along with it. You're good. This is really strange. No other region in the country has ever said this. Every other region has said you absolutely cannot do this. You're opposite. So, welcome to the world of benefits and just kind of all convoluted and contradictory situations. But at least in Illinois, for right now, able accounts are a great tool because then you can have the child support go there and not have to spend $1,000 on a first party special needs trust just for child support. And right now there's no payback on able accounts. So, okay, you get rid of a payback provision. The other thing, one of the other things that has changed recently, and this child support court order thing that changed very recently in the last year. This other thing changed a few years ago, which is an additional provision of the ABLE Act was added that you can now convert 529 college savings plans to ABLE accounts up to the amount of the cap or 70,000. So if you already put 70,000 in the ABLE account next year, you can't also convert some of the 529 plan for the benefit. But this can become very useful for some of our families who have a significant 529 plan. They're never going to spend it. This also is a way that we get around that $17,000 annual gift tax exclusion. If we have a wealthy grandparent who's trying to make gifts and wants to benefit that child with disabilities, we have them oftentimes give to the 529 plan for their benefit because it's an exempt asset, and we can convert to the ABLE account to use it later for that benefit. And if we don't do that over time and the 529 plan is still there when the child passes, there is no payback ever, because 529 plans don't have that. And you can change the beneficiary to some other relative, grandchild, whatever it might be, and then the money will still actually be utilized. So anyways, that's a nuance there. When it comes to the one other piece to this that was really important, that it's actually the 2017 Tax Cut Jobs Act that happened during the Trump administration. They added another provision that's really good, which said that a child who is individual with disabilities who has an ABLE account and is working, so they have a Social Security, they have SSI, SSDI, which generally you have to have to qualify for ABLE accounts, not always, but generally the concept. So they have Social Security, they have some part-time work earnings. They can actually save their work earnings above and beyond the $17,000 cap next year, $16,000 this year. So there's one key nuance: they can't actually contribute to an employer-sponsored retirement plan, which they shouldn't be doing anyways, because 401ks or whatever IRAs they have at work, if they contribute to that and the employer matches it, that is not a good thing, because what ends up happening is that money counts. Every dollar of that counts for the $2,000 asset test, and very quickly we have a problem. They've lost their benefit. So do not participate. It doesn't make any sense. But to let's say I'm going to give away the free money of that employer match, do not have them participate in the retirement account. It's just not worth it. But one of the other benefits of not participating in the retirement plan and opting out of that employer match and all that is that the ABLE account then has this extra ability to receive contributions beyond the $17,000 limit for up to every dollar of work earnings they've earned effectively. Because federal poverty level is over the Social Security SGA amount, so that doesn't really limit them. What limits them is just how much they work. So basically, if they earned $1,000 a month, they have $12,000 of extra cap in the ABLE account that year, right? So that's a pretty big deal. How they can put 29,000 in that able account, not just 17, which gives them a lot more space to put excess Social Security work earnings, or again, convert some of the 529 plan money, whatever, to whatever the case may be. So that's a nice nuance we're able to utilize there. Again, I mentioned this already. There's a whole slide on it. The fact that Illinois is not enforcing the payback provision that they're required to under federal Medicaid rules. That is, it's kind of a frightening prospect because Illinois is dependent on Medicaid. It's billions of dollars a year. We would be immediately insolvent if we didn't have Medicaid. And the federal government, it's federal law that if the state does not comply with Medicaid rules, they don't get Medicaid. So it's a big mess that Illinois is refusing to enforce the payback and able accounts. I understand why they're doing it. They're trying to get as many people to join the able program as possible to keep it financially viable. But it's not going to work in the long run there unless the federal government changes the rule. There is also a statute that Illinois passed to give a state income tax deduction to able accounts, just like 529 plans. Remember, we're limited to that $17,000, a year. So, even though it's a $20,000 for a married couple, a tax deduction is really limited to $17,000. And also remember, I don't want parents and grandparents putting money in here, even if you get a state income tax deduction, which is only the 5% state income tax, not federal deduction. You have a payback when the child passes, potentially, as we're seeing here. So it's the state income tax deduction not that worth it to my estimation. All right, so information request for number 11. Again, go to the link on the website, calendar events. Click this tonight's presentation, and you'll see the link to all that stuff and to fill out the forms and send those. All right. So if we're not, able accounts aren't a good option. First party trusts are kind of last place we go to if we have to, which is a large amount of assets, whether lawsuit settlement, whatever it was. It's incorrect inheritance, left to the child. This first party special just becomes the option here. A lot of different names for overnight 3, D4A, payback trust, because when the child passes, there is this payback to the state as we see. So get medical and practice personal injury settlements, what have you, as we just discussed. And there's a whole thing that, by the way, if someone is going to pursue a case, they should really have some sort of special planning attorney be involved from the beginning. And of course, if they are looking for the attorneys to do those cases, you want to find someone who's obviously doing birth injury cases, not car accidents and everything else, and also birth injury cases. But either way, in those situations, you want to make sure the specialist planning attorneys are involved from the beginning, because they can basically allocate the settlement from the beginning to, or as much as possible, to the parents, which does not have a payback on, unlike the amount that goes to the child, which does. And there's some other pieces to it, but it's definitely beneficial to have someone who knows about all these rules when they're even filing cases. But aside from that point, whatever the situation is, if there is that kind of settlement, lost settlement or verdict, if there is inheritance or gift left directly to that child, that is that we can't get it out of it now. It's in that child's name. The child has their own assets. If they're turning 18, child support again beyond that threshold of the $17,000 a year, then we use this kind of trust. It's a special needs trust, so it does have the commonality of a reserve fund over to the government benefits. It could have millions of dollars in it without affecting benefits. It could allow up some assets just like a person. But big caveat: when the child passes away, the state has claimed for reimbursement for whatever they paid during their lifetime, and even is before funeral, to the able accounts. I don't get to that too. The first party trusts do. So it's pretty ridiculous. Everything is paid back before you pay anything else the minute the child passes. And of course, like I said, it's my brother's case, for example, that's millions of dollars, $140,000 a year for decades. It is an interest-free loan because they don't charge interest on it. So even if it was, if the state paid $140,000 in 2022 and it's now 2050 and my brother passed, and there was a payback trust, they wouldn't get any adjustment. It would just be the amount they paid in that year, even though due to inflation, that would be worth a lot more in today's dollars. They don't get that. So just the actual dollar they pay back. But it is still obviously going to wipe out most, I would say, first party trust for someone who got long-term support services like group homes or things like that. All right. Okay, thank you. I see that in the chat box. You can see it. You put the link here to the calendar of events where you can find tonight's presentation and click to learn more about it. All right, so there's other reasons that first party special interests are not so great, including the payback, as we talked about, but it can't be used when over 65. It can't be established by siblings, only by parents, grandparents, courts, guardians, or the individual themselves. Social Security has a position where they say, SSI in particular, that if they want court approval for, if there's if the child had a guardian appointed as an adult and there's money in their name, they want the guardian of the estate opened out in Cook County. That means annual accountings every year, the rest of that child's life, thousands of dollars a year in attorney fees. It's a big mess we want to avoid if we can. Courts often will require these annual accountings for Cook County. Hopefully other counties we can get around it, but Cook County is a big stickler on it. And that just eats away at whatever the money is. So again, it's not a good idea. And it's why we want to educate our grandparents and aunts and uncles to not leave money directly to them. And again, there's that payback going all the way back to birth, basically, any Medicaid funding. Now the first party, especially just again, is required for child support unless it's under the threshold for able. Divorce is a whole complicated scenario when there's a child with disabilities. And most family law attorneys, divorce attorneys have no clue and mess this up all the time. Teach the continuing education courses to divorce lawyers for all different ISBA, the state bar, nationally done in service to large divorce firms, the large divorce attorney firms in the state. But there's so much ignorance about it in the divorce lawyer family law world. They cannot, child support has to be recorded in first party trust or an able account. The life insurance it should not be ordered in some sort of language they usually use of a trust with the parent as a trustee for the benefit of that child for the support. That would be a resource. We have to have it allocated to the third party special needs trust. When it comes to health insurance plans, the 26 law, they can go on past 26. Again, the divorce lawyers don't know what they don't know, and they don't realize they can have a court ordered in a divorce decree in the marital settlement agreement that the parent can keep the child on as a dependent health insurance plan after age 26. They also, so health insurance, life insurance, you can even have a court order that says that one of the parents is required to have life insurance paid directly to the third party trust for the rest of their life, have permanent life insurance, maintained. Could say they have to have a piece of their estate left in the special needs trust, the third party trust, so all of that. Okay. Now, all right. So then, again, information request from number 3. Again, go to the link chat box there. So we know we don't leave money directly to a child, only to third party trust, and only if we have a mess on our hands do we really use first party trust, or again, able accounts to become a tool in some cases. All right. One of the things to note with that nursing impoverishment exception, where grandma or grandpa, aunt or mom or dad, or even aunt or uncle, but anyone could put money into the special interest for that individual disabilities and immediately qualify themselves for the state nursing care without any look back at all. 5-year look back period that only applies to not. One of the issues is that by the time someone needs skilled nursing care the next day, they may have lost capacity ready to make a transfer. So what we'd like to do is get in parents' documents, maybe even the grandparents and aunts and uncles, anyone who might do this, get in their documents that if the power is returning, they're working in trust, that if they lose capacity down the road and they need skilled nursing care, that even if they lost capacity themselves, their successor agent or trustee has the explicit power to transfer assets to the special needs trust with the explicit intent to qualify for Medicaid for skilled nursing care. It's like magical words you have to have in there for the state to allow you to do it if they've already lost capacity. So that is something to be noted. To note, also some states require to go to a first party payback trust. Unfortunately, most states like Illinois like a third party trust, but some of them have more restrictive rules about other provisions in the trust document. Illinois is not as restrictive on that. All right. So this talks about what do we spend first? They're working and making a few $100 a month, $800 a month, $1,000 a month, but obviously still getting the benefits. And they're getting Social Security, they're getting SSI at $914 a month, or reduced amount, they're getting Social Security parents record, $2,000, $3,000 a month, or whatever it might be. You got to spend that money first, because if they don't spend it and go over $2,000, they lose their benefits, right? The next step is you move the excess money to an ABLE account, maybe, but the ABLE account or the first party payback trust is the next money we ever spend, because once we spent down this money, we're below 2,000. We save the excess to the ABLE account. We want to spend this during their lifetime. This we want to spend each month. This we want to spend during their lifetime, because when they pass on, the money goes to the government, whatever's left when they pass, in most cases that we're dealing with. And then the last money we ever spent is that third party special needs trust, because when they pass on, when they die, the money stays in the family, right? It's not disappearing. It goes wherever the parents who set up the trust, in most cases, want it to go. So many of you may already have a third-party special interest established. And so I like to go through kind of, what are the things to look for in that trust to make sure it's going to work as a good, valid special needs trust. All right. So the Social Security and Medicaid have to approve a special interest that's funded. So in many cases, the trust isn't funded. Certainly, if it's inside the parents' estate, but that doesn't even exist yet. So maybe that was never submitted for approval for Social Security and Medicaid. But once it is funded, it has to be submitted for approval by Social Security and Medicaid. So you may not know until you're gone whether or not it truly is valid special needs trust. Will it be approved when it is submitted? And again, you have to submit it within 10 days of any change in circumstances, including funding the trust. So the thing to be aware of when it comes to the special needs trust is, most estate planning attorneys are, they have some form that they found or they have online or something or that they've used before. Unless the attorney you're working with does a lot of this, does at least five special interests a month, or certainly at least a few dozen a year, whatever. The chance of them being on top of all this stuff and that we're about to go through is pretty unlikely. But there are a handful of people, in the state that do a lot and would hopefully not make these mistakes. But so as we go through these attorney mistakes, for those who don't have a special needs trust, it's still helpful to understand how the trust works as we go through them and what can be in there, what can't be in there, all that. So constantly a special trust doesn't make it. So just because the attorney drafted a trust called a special needs trust does not mean that it has all the qualifications that are required to have in it for it to be a special needs trust. So usually the technical requirements, most people don't mess that up, but I have still seen it happen where people mess it up. But hopefully it's not so common anymore. But they may not have what we call grandfathering support language. Now, if the special interest is written without language that refers to the not only the state statute that was updated in 2020 for special needs trust, but also the Medicaid regulations, Social Security POMs that are relevant to special needs trust. There's just internal Social Security manual, basically that Social Security uses for SSI purposes, at least. Again, the Medicaid regs, if it doesn't cite those things and they change them on us, which they do from time to time, then we're not going to be grandfathered. We don't even have a chance of being grandfathered. State law and court decisions in accordance with state law have said that if you don't have grandfathering support language, you don't say what laws you relied on when you set up this trust, you don't say the regs you relied on when you set up the trust, and those get changed on you, even if you would have been grandfathered had you cited it, we're not going to automatically grandfather. So the language should be in there, we're citing all those things, okay? What else? We do not want to prohibit, we want to prohibit first party money. So it would be a mistake to, it would be to not prohibit this. First party money going into a third party trust. So again, one of the key things we want to do is say, hey, trustee, do not accept that money that's from that child. If it's from the Social Security money, whatever it is, it can't go into the third party trust, right? We also want to tell the trustee, hey, if there is a first party special needs trust, if there's an able account out there and you can use that money for whatever it is, it's not something there's certain things that we really can't use the first party or able account money for, but that's not quite clearly for their sole benefit, basically, or loosen the rules on a little bit, but basically their primary benefit, I guess is how we would phrase it. And we'll talk about one of those big exceptions where that is a problem. But for the most part, we're going to use that first party trust or able account money first because there's potential payback when the child passes on. Third party trust, we don't want to spend down if we have other money to spend because it does stay in the family. We're not in a hurry to spend it. One of the mistakes we see is that they'll make it they'll make it limited in certain ways. They won't make it 100% discretionary. Under Illinois law, the statute of special needs trust, the trust is 100% discretionary. The trustee has to have full, exclusive, complete discretion over distributions, and many times we see that they don't. That's a problem. It also should not have language that says that the trustee may pay money to, or so it'll just say to or for the benefit of that the beneficiary with disabilities. Because by having that language in there, first, it's tempting the trustee may pay money to them, which they lose their benefits or reduce their benefits. But beyond that, it is language that Social Security can sometimes give you a hard time. They'll say, wait, if you allow money to be paid to them, That means that we're going to audit you effectively every month, and we're going to want you to send in statements every month to show you never pay money directly to the child because you're allowed to in the trust. So we don't want that language in there to begin with. It's just a red flag for SSI offices. And if the trustee does act on it, then they would lose, the child would lose their benefits. In addition, instead, what we recommend is consider having language in the trust that says the trustee may distribute money to an able account. Okay, and that will again allow the child, maybe if they're more independent, to have some spending money using a debit card on that able account without causing a problem with government benefits. Because as you remember, hopefully able accounts are completely exempt from all any issues with eligibility and asset tests. Also, first-party trusts, the payback trusts, can have a provision. It's been they've said this now many times. The federal state level can have a provision to say you can distribute money to an able account. You basically, under current Illinois law, Illinois law, and the way we're enforcing it, which is complete conflict with federal Medicaid regs. We're not enforcing the payback, so you can basically out the back door take money from a payback trust that has a full payback on every dollar of Medicaid ever paid every year to the able account and get that money to a place where Illinois is not enforcing the payback. So there is a loophole here for the time being as well, that you might as well have a language to allow for the trustee to do it if it's the right thing to do. All right, overly restrictive language we'll see in trust sometimes. It'll say that the trustee cannot use the money for food, shelter, or clothing. First off, the clothing language, that concept has been around since the mid-2000s. That's with old language if it's in your trust. If it says you can't use the trust for food or shelter, period, it doesn't have any language beyond that, or only if you use everything else first. That is also language it's not ideal, because the SSI rules about you can't use money for food or shelter. If you want the full SSI amount, reduce it to $600 a month next year. That language, that only applies, one, if the child's on SSI. Two, if we really want to get the full amount and not get the reduced amount because we say forget it, the $300 a month is not a big deal to us. We have other priorities like making sure that we have the housing we want for. And three, for most of their life, they're not going to even be on SSI. They're going to be on SSD on the parent's record, hopefully, which does not have this. And Medicaid doesn't have this. So to have language that says you can't use for food or shelter is ridiculous, because it's not going to apply to for most of their life. And even when it does apply for a period of their life, it may just be worthwhile to just take the reduction of SSI. Also, there has been talk that SSI is going to get rid of this rule in the next few years because it's just a hassle to enforce. So again, don't want over restrictive language. You can have language that says you don't use food or shelter unless the trustee needs it to be their best interest. That's fine, and that's something we've kind of for over the years have done. But we definitely don't want to have it say don't use food or shelter ever under any circumstances. All right, or even say only if you spend everything else. We don't want that. All right, so we also want the trustee to have the power, or a trust protector, someone have the power to make changes to the trust if the laws or rules change on us, and we're not grandfathered. We've seen it happen where Social Security says, well, yeah, we're changing our interpretation of the rule. And so we're not going to grandfather you and enforce it immediately on all trust. So we want to try and have the ability to make changes, at least change trust going forward, and not have resources forward. And if they do that to us and they say we're retroactively applying to the trust since it's been funded, then we try to have a retroactivity clause. So our change is retroactive to the date of trust of existence. Kind of try in a battle of of arms race between the Social Security and the trust document, but it can't hurt to have that language as well. Next generation trustees. Now, let's say that the beneficiary is younger than the people we're thinking of naming by a number of years. Right? Sometimes we'll say, well, we're looking at the siblings of the parents, right? The aunts and uncles of that child to be trustee. But at some point in the future, we would be looking to to the next generation. Maybe it's their siblings, the other children, grandchildren. At some point, maybe it's again nieces and nephews, whatever it might be. We want to build in that next generation trustees. And one of the things we like to do in our trust document is say, hey, trustees we did name, if we don't get around to updating this to add that next generation on as we more advanced age, the trustees we do name, they have the power to do that themselves. And then always have a backup filing corporate trustee if just in case we don't have a default situation where the individual with disabilities becomes their own trustee and then the special interest doesn't work anymore. This is a very, very important provision that almost I would say 95%, more than 95% of the trusts we review from other attorneys don't have, which is language that says you can make charitable contributions to organizations providing services to the child or that may be providing services in the future. And the reason for that is many. Number one, there's a long waiting list to get into this agency, or there 20-year wait for Lamb's Farm, Misericordia, Clearbrook, whatever it might be. All these different agencies, long waiting list to get, to get services, to get maybe if you're funded. Once you've been funded to get into these organizations, especially Lamb's Farm, Misericordia, they not even part of the PUN system of the waiting list. It's kind of, they have their own waiting list and they choose who goes in. Now, the reality is that over the years, people make charitable contributions, it potentially opens doors to agencies across, the board. And this is America, and it's probably not surprising to people. And so if parents are gone and the trust has the available resources to do so, they want the trust to be able to make that charitable contribution to open those doors. We also want the ability to make charitable contributions to the organization providing them services, because we may need to subsidize their Medicaid rate. My brother's group home was a 3-person group home, 4 and 3 back and forth over the years. But when it's a 3-person group home, the Medicaid rates are such that there is a big deficit for that group home to what Medicaid's paying with the true cost of quality care is. And so our family and other family are making charitable contributions to Clearbrook to help make the budget work for the house, that they're not losing too much money on it. Otherwise, they would be forced to have people share bedrooms maybe, or whatever it might be. So again, charitable contributions become crucial to subsidize effectively, voluntarily subsidize that rate to somewhat customize maybe what's going on in the group home they may be in, to comply, to fulfill charitable commitments that have been made by families, when the child moved into the agency or whatnot, and also to buy goodwill and influence. You go to the annual dinner and buy a table every year, and if mom and dad are gone, the siblings, should be able to have the trust fund pay for that cost for them to go with their spouse and maybe their friends or something, so that there's that goodwill, there's the influence, there's the show in your face that the agency, the executive director, the associate director, the people, the top 3, 4, 5 people in the agency know who you are and know who the family is and know that you support the agency. Obviously you're not supposed to treat anyone differently, but let's talk about the reality of things. And if that person calls and goes to the annual dinner every year and maybe even buys a table at the annual dinner every year, they're probably going to make sure they call that one person back first before the next person. So these are all things we want to make sure we allow for practically. And one other piece to this, my brother's group home is, it's owned by the agency. They don't have a huge budget for renovations. So, here and there, obviously keeping, just a repair, that's fine. They have people in the house for some large agency, but, if they need to redo the kitchen or replace appliances and stuff, there's really no money for that. And it's kind of, they're going to do whatever the minimum they can do and can't buy. In most cases, they just don't have a big budget for that. So if there is the ability, obviously they'll try to use fundraising dollars to do that in general. But if you want to move ahead of the line and say, let's replace this the right way, now if the trustee is authorized to make charitable contributions, they could write a check to that agency and then have the agency pay for the new fridge or redoing that bathroom that's 40 years old and falling apart. So those kinds of things. Gift language, the ability to gifts to staff. Yes, gifts to, if there's a niece or nephew's birthday party and they can bring a gift from them, and aunt or uncle bringing their gift, a nice idea. But maybe more importantly, or definitely more importantly, is being able to give gifts to staff. It's Christmas time. We want to give $500 Target gift cards to if there's sufficient dollars in the trust to do it. $500 Target gift cards to each of the support staff and maybe the Q, the person who manages the group home, maybe other people, depending on the living situation, because we want to buy goodwill and want to buy influence. If that family or the trust at this point is doing these things, you better believe that when that sibling or relative, whoever is the guardian, trustee calls, maybe they're gonna, the person, the staff, has their cell phone number, and they call them when there's an issue. They will find out from them directly, not waiting until the agency calls them about something that happened. So again, buying goodwill, buying influence. This is just the reality of the world. This is, it's not pleasant sometimes to talk about, but it's reality. And we want the trust to be able to be very flexible to do these kinds of things, because it oftentimes these things will, in many cases, be the largest expenditures that special interests will make. The only reason there are special interests out there that have $5 million or $6 million in there, from obviously affluent, very affluent families is because of this stuff. Because the expense of these children are not usually very, they're not going to Bora Bora and, and over on a bungalow and spending, going on private jets or something. They're not spending fortunes on this, on those kinds of things, but they're spending money on this stuff. This is really contributing to quality of life for them. So, all right, tuition version not really relevant to most people. Get into that if you want to ask. Contingent language saying that if there's a individual with disabilities that is, some other relative, grandchild or great grandchild, or great niece or nephew, whatever it might be, don't give them money directly either, or put it into their special interest so they don't have one, create one for them. That language I'd like to get in every single estate plan document ever created, because it would solve a lot of problems. So there would never be these incorrect inheritance left directly to the child or to a bad trust fund. All right, then there's some impoverishment provision. There's language that state here in Illinois, it's pretty flexible. How you can, what language you can do and what's required. But there is some weird kind of magic words they want in there that don't actually have real meaning practically, but you need to have it in there for them to qualify as they call a sole benefit trust for Medicaid voucher purposes. There's also, though, some states that have even more requirements and restrictions. So depending on if grandma lives in another state, this could be a real issue. Is there specific language in special needs trust? This is another huge one. Anyone, who are talking to today, or there is any connection, to someone who is getting TRS, they're a public or will be receiving TRS in retirement, they're a public school teacher in any district outside of CPS. They are a state university or retirement system benefit recipient, or will be because they're a university professor at one of the state universities or one of the community colleges, etc. They have a military pension. They have a state employees retirement system pension. They're a judge retirement system pension. They have any of the state pensions or the military pension. They can go to police pension, downstate police, fire pension, all these places. They can go to a special needs trust. This is really, really an amazing benefit that if you don't know about it, it's a big, a huge loss. And if you do, you have to follow the rules. And if you do, it's a huge, huge deal. So the TRS, the teacher return system, state university return system pensions, those can go to a special needs trust after the parents have died. It's a crazy benefit, doesn't exist in any private sector pensions, except doesn't even exist anymore. But it's huge because that child now, if you have a career public school teacher, that child's special needs trust is likely to be getting 30, 40, and depends on what high school teacher, if they were, what district they were in, if they became an administrator at some point, their pension could easily be at least 30 or 40,000 a year, or the pension that would go to that child, it'd be 30, 40,000 a year. In some cases, where it's 80, 90,000 a year, and it's the TRS pension is 50% of what the parent teacher is getting. And if they have two parent teachers, they have two teachers who marry each other, they both have TRS pension. I mean, we're talking major dollars. Could be 100,000 a year going to the special needs trust for that child for the rest of their life with a 3% COLA on it. So it's a big deal. But to have that happen, and the police pension actually is 100% what that police officer was getting in retirement years. For these pensions to actually go to the special needs trust, we have to data-rise, cross our T's, we have to follow rules, we have to do some of our tax returns every year for the rest of that parent's life. We have to put the right language in the beneficiary designation for the state pension, whatever it is. We have to follow all these rules, and put the language in the special trust that is explicitly referring to those pensions and pension code and all that. But if you do all that, I mean, if we're able to get 30, 40, potentially in some states, over $100,000 a year of pension, that child special interest guaranteed every year with a 3% COLA for the rest of their life, that is life-changing for that child, and just what we can do with that money and how it can be used. And it's third-party trust money, so we can do charitable contributions and all the other stuff we talked about. So that is huge. It puts the retired school teachers in a position where their trust will have the same kind of potential ability to do things as people, multi amount of trust in very wealthy families. So it's crazy benefit that we do not want to miss out on. So we got to follow the rules. We got to have we do not want to mess anything with that up. All right. The ability to change if they move states, they're living in a different state and they have different Medicaid rights in that state, the ability to make the changes in the trust should be there as well. The wills the parents have will nominate guardians, not just minor children, but as an adult, they should nominate for a guardian to a civil person, whether it's needed, now and they're ready, parents are guardians and we need successor guardians nominated, or in case of guardians. future. The Parents Revocable Living Trust have language in there throughout that in traditional other estate plan documents for the revocable living trust that is problematic for special needs planning and capacity and all kinds of other provision. It's not just, oh, well, they said that anything for the child goes to special needs trust when we die. That's not good enough. There are other provisions there that are really problematic in the boiler language that attorneys will use in living trust. Irrevocable life insurance trusts are notoriously difficult to draft when there is a child with disabilities. We do it regularly because we're so hyper specialized in this, but it is a big problem. Almost always those things are problematic unless the attorney drafting it very knowledgeable what to do with special needs planning. The powers of attorney have to have certain language in there, should have certain language in there because things will come up with special needs planning related stuff. And of course, we need to make sure the beneficial information can update. All right. If you want more information about administering special needs trust, how the special needs trust works, there's a special trust handbook that we can send to you. Then look at that link to get more information about it. Item number 1 in our request form, that link is that handbook. Item number 6 is the reading material about special needs trust and planning. And if you have trouble sleeping at night, you can read our articles on special needs trust and taxes. It is pretty simple when the parents are alive in most cases, but when the parents are gone, or if it's funded by third parties, like grandparents, it can get super complicated and how it all works. So if you have trouble sleeping, like I said, if you do that, or you just have to be a tax nerd like myself, then you can read that. All right. So excellent. Double that slide there. All right. So one of the things we need to think about when we talk about special needs planning is how do we divide up the estate? How do we divide the assets, the inheritance between the individual disabilities and maybe other children if there are other children? We talk about separating head versus heart, and I want to do everything equally, but I'm trying to balance things. Saying, hey, I want to make sure there's enough money for that child with disabilities because they're the priority because they can't support themselves financially. At the same time, they're going to have benefits and services, and at the same time, the other children should be able to support themselves financially, and so inheritance should be a bonus and not just something that's necessary. But we also don't want the other siblings who are maybe the successor trustees and guardians to feel even subconscious resentment of the fact that most of their life, their parents spent the majority of their time for sibling disabilities and focusing on them and on their death. Inheritance went disproportionate to them as well. That doesn't sit well with a lot of people, even subconsciously maybe. So that's something we talk about. We talk about sometimes formula saying, hey, if it's kind of like a message to the other kids saying, hey, if the estate is large enough, if our estate is over X dollars, it's over a certain number, over a certain number of millions of dollars, we maybe don't expect it to ever be, but if it was, I would love it to be equal shares. You put that in the document. But if the estate is more, realistic, maybe it's going to be disproportionately going to special needs trust. You're telling the other kids, hey, I would love it to be equal shares, and if I had enough money, it would be. But unfortunately, I don't, and so therefore, I want to make sure that your sibling is not financially dependent upon you, and so therefore, I'm leaving more money. The special needs trust, knowing that if there is money left over, it's going to go back to your. Sometimes we'll have the estate plan say equal shares, but there will be a survivorship or second life insurance policy that pays in the second passing. Parents get its permanent life insurance policy that is cheaper than insurance on one life or the other life that pays directly to the special needs trust. It's a bonus amount to the special needs trust in addition to the equal share. And sometimes we'll say a percent of this asset or that asset, it's a higher percentage of special needs trust. People play games with that and can change those things over time, etc. Even the actual estate plan, wills and trusting all with equal shares. One other kind of pickle throw into this is the Secure Act, which says that basically, and we're running over time here, so I'll hurry up here. But the Secure Act says, that we said IRAs, 401ks, and special rules about it, and so it may be there's kind of different ways we can go depending on situations that it's beneficial to leave more IRA assets to special needs trust because of this special stretch rule. We have a special needs trust, but maybe because trusts have worse tax rates, depending on how much we spend in the trust that goes on in the child's 1040, we can end up in an issue where it costs a lot of money. All right, so this last piece, section here is talking about, and we're kind of very over on time here, so I'm going to just go through it briefly and we'll answer questions. I just want to make sure that people want to answer questions can ask them before much longer past our 8:30 original end time. But basically, the general concept is when someone turns 18, they lose the parents lose all rights for them, And so we first want to consider, well, before we jump to like court guardianship proceeding, let's look at what the alternatives are. Alternative of doing nothing. Well, if they don't have capacity to make decisions, but you never did a guardianship, then when it comes to medical decisions, the Illinois Healthcare Surrogate Act says that you can make decisions for them as parents, basically. Long story short. Again, they have lack decisional capacity, have no healthcare power of attorney, not have a guardian appointed, not be married, not have children, but the end result is for most cases, the parents make decisions. All right, but if they have decisional capacity, then we can look to something called sport decision making. It's a very popular concept across the country. It's spreading everywhere. This idea of having them participate in decisions about them, and the idea of saying there's no decision about me without me, kind of mantra, and self-advocacy and all that. Well, that's really important and great for individuals who are able to do that. There's a form that Illinois created, and revoke at any time the individual disabilities. They cannot make decisions. The person, the parent, let's say, who's the sport decision maker, cannot make decisions on behalf of the individual disabilities without the individual themselves. So all it does is really give you access to information, help, and be able to help with things and avoid HIPAA and privacy rules. Okay, so that is not going to be sufficient. My brother's case, obviously, that was never going to be sufficient. And if you want the information request form again on that link we keep talking about. Option number 3 is you say, okay, well, they have divisional capacity, but you know what? I need more than that. I need to be able to do things on their behalf. Well, a power of attorney would do that. It doesn't take away their rights to make decisions, but it does give you the ability to be a co-decision maker and make decisions on their behalf without even needing their approval. Once they sign this power of attorney, it's immediate, it's drafted that way, you're able to cover everything from filing their tax returns for them, dealing with group home stuff or employment, job coach stuff, or first party trust able accounts, HIPAA privacy lease, user IDs, passwords, all that. So healthcare power of attorney, special education power of attorney, mental health treatment form for psychiatric treatment, Social Security and Medicaid have their own forms that could be signed. And then the individual disabilities is given the parents the ability to take care of things. But if that's not enough, and they're still vulnerable to some other people, like my brother, then we're looking at the next big step, which is, they need guardianship. And so there's different kinds of guardianship, but regardless of the type, you're balancing independence with protection, and it's a whole court process and a lawsuit, and it could be traumatic for individuals a little more understanding of the situation, and has a higher level of just comprehension of it all. For my brother, was completely over his head. But that said, the guardianship process can be, it's a lot of pieces to it. Require notices, obviously you can hire an attorney. We have an attorney in our office. Does one of our associates for a long time did nothing but this work for our firm, and the guardianship representing our parents. But you could do that. You can do it on your own. It is so complicated. And again, you have to be a resident of the U.S., not necessarily Illinois. That's the kind of the main thing we run into sometimes with who guardian. Parents can be co-guardians. Sometimes when parent passes, we bring a sibling on as a co-guardian with a surviving parent, so we don't have a gap when the second parent passes, and have who's going to be no one's guardian for a few weeks when the second parent dies. We don't want that. You don't have to do it at 18, but probably a good idea to do it if they need it when they turn 18. If it's guarding the person only, there's no money in the name. It's a lot simpler. If there's money in their name, it's a lot more complicated and more expensive. There's other times they just go back to court throughout their life, residential placement, if they're going to home, it's also approved by the judge. Anything reproductive rights wise is a very hot button topic. Since 2009, courts require additional court hearing to deal with that. And it's very, very difficult to ever do vasectomy or suicide if there's a guardianship. It's very sensitive and a topic we can talk about if need be at the end. So moving out of state, moving out of county, state, you have to transfer the guardianship to the new state. Move out of county, it's up to the judge if they make you move to the new county. Some people will decline to act as guardian. They're worried about liability issues if somebody hurts someone, damage property. Sorry, if all medical decisions the guardian can make without any further order of the court, including end of life treatment, but they cannot have a driver's license if it's a guardian. If it's limited guardianship, they can. If you want more information about this issue of driver's license and not being valid if they have a guardianship, it's a big issue we keep running into with our clients who were basically ill-advised to get a plenary guardianship when the child had a driver's license. The driver's license becomes valid. So limited, there are a lot of have a driver's license now. Guardianship. You have to look at this training now for online course if you're a guardian for a child, for 18. So just facility, they require this online course now, even if it's a parent who's become guardian for their child. There's sort of guardian declaration, which is a legal document. You can put someone in charge of your child temporarily while you're out of town or something. That applies for the adult guardianship. Let's see here. Guardians already in the wills. You know, that basically just consider that even if you don't think we're ever going to have a guardian, you should still nominate just in case. And then how do you balance, who should be guardian? It's a whole discussion in a personalized situation, and of who should be guardian. Just, separate necessarily from trustee, could be the same people, could be different. There's benefits and drawbacks to all that. And the last thing we're going to talk about is, we're going to put questions here, is apologize for going over by about 20 minutes here, is writing a letter of intent and guidance that you can get your team, writing a book about child history of diagnoses and medical stuff, behaviors, do's, don'ts, buzzwords. If you're thoughts about the future with special education services, transition plan, transition program, adult activities you like to do and don't like to do, or employment options or things that maybe good fit for them, thoughts about future living situation, the history of living situations that didn't work out or are working pretty well now. When someone's passed on, how do they process it? Last correspondence, Social Security, Medicaid, the tons, all that stuff. Where the statement documents are, special needs trust, funeral desires. A lot of times people bought plots for the child to be buried next to them. Write that stuff down. No one wants to talk about it's morbid, but at least put it in the documents. So this letter of intent, they know about it. And then the executive summary. How do you get through the next 24, 40 hours with that child? Right. All right. So more information about all that and how to fill out that from a fillable PDF form to document all those different options is on that link, and also articles about it that you can access as well. All right. So now, sorry, again, 20 minutes late, I am opening up to questions. Thank you for staying awake and staying with us here. And I apologize for speeding through guardianship. So if you have questions about guardianship, I'm happy to answer. I just want to make sure I got plenty of questions so that people who need to go to sleep soon or whatnot, or go back to kids that they're able to. All right. Thank you.
I just want to announce and remind everybody that we are recording, just in case if you'd rather type into the chat versus speaking out loud, that's completely fine, but we are recording tonight. And just while I have you, we will be sending the recording out probably within the next week.
Any questions? Did all jump at once? Thank you. So Margaret, I raised her hand. So here.
I unmuted. I'm sorry. Barney is playing in the background. So, so I have a question about when we talked about like life insurance and beneficiaries. So my husband and I just recently we're trying to get our finances together, and we got new life insurance policies, and we started an annuity. And in that, we didn't want the beneficiaries to default to our children. We have two children. They're 20 and 23, both with special needs. So we didn't want them to default as I had to pose it to the people, what if me and my husband were in a car accident and we died? Like, we don't want any of that to go to them. So we named another person. Did we do that right?
So it could be a temporary kind of we have no other option because we don't have a special needs trust. We don't have our estate plan in place. But if you have an estate plan in place, if you have a special needs trust, whether it's a joint one, do them together. There's pros and cons of doing that for two children with disabilities, or separate trusts for them with 50% each or whatever it might be. The trust, if you don't have your estate plan in place, you can temporarily do that. But I would never recommend it be the permanent solution, because when we talk about that moral obligation, right? That do
For
that,
sure.
That money can be gone in a divorce settlement, an IRS credit account, where they die and the money's left to their kids or whatever, and now they have no moral obligation to use it for your kids. So we tell families is maybe for for a few months till you get your estate plan in order, sure. But once you have your estate plan in place, you obviously update those beneficiaries to either refer directly to the special needs trust or to your local living trust, depending on the structure of the estate.
Okay. I guess we were just doing it because it was all happening so quickly. We still have to do like their special needs trust or whatever we're going to do. But we were just trying to move our money as per se. And but if we died next week, I got it's horrible. If we were in a car accident, just the two of us next week, would there be anything that would take all that money and would it default even though we named somebody else?
No, the beneficiary designation is binding. So
Okay,
whoever you
okay.
name is where it'll go. Now, obviously, again, you're relying on more obligation, and there's different schools of thought of would I rather just go directly to them, which then would have to be moved into a first party trust and all the expense and hassle of that. Probably
Okay.
not. But there's payback and all that. At the same time, more obligation is more obligation. Whereas if it went to them directly and we moved into a first party trust, it could only be used for their benefit. But as long as you have complete faith and trust in these people, and it's only a temporary thing, for let's say not more than 6 months to a year, then fine. I think it may be a decent option in your situation.
Okay, that was our intention. And I just real quick, you did mention to share a special needs trust. Would you more recommend separate special needs trust? Because that was the way we were thinking anyway.
Most of the time, when we discuss the pros and cons, we end up having two separate,
Okay.
kids are separate special needs trusts for a lot of different reasons. There are occasions where having a sense, but it does make it a little more complicated to administer, and there's a lot of factors that generally choose to not do that and keep it simple. So,
Okay. Thank you very much. Thank you for tonight.
sure, of course. Thanks for listening. Anyone else? Any questions? You 30 seconds, and if not, we'll people go to get ready for bed. Thank you for listening.
You know what? It's going to be me again. So I have one. I wrote down about the difference between how they get categorized as an ACA or an AABD.
Mhm.
Like, I don't know how it happened, but my son is categorized as ACA and my daughter got categorized as AABD. I think it was because she turned 19 during this whole COVID thing and whatnot. But should they be one or the other? Is one or the other better?
So how's it one of those better? The issue here is Illinois is a complete mess. And with COVID, they stopped even enforcing stuff. And so everyone's in ACA, and they want everyone to be in ACA Medicaid because it's almost a free ride for Illinois. Basically, with Affordable Care Act Medicaid, the federal government is 90, it used to be 100%. Now it's 90% of the cost of Medicaid. Whereas for traditional Medicaid, they only pay 50% or half. So they want everyone in ACA Medicaid because it's a huge increase of what Medicaid's paid from the federal government. The problem is that most of the people that they're trying to shoehorn into ACA Medicaid don't actually qualify. Most or a lot of them, a large percentage, and so it's not working. But that's not your problem; it's kind of the state's problem. And so just at some point, my only concern is at some point you may get a letter saying, "Up, they've lost their ACA Medicaid, they're off Medicaid, they have no service, and now they're losing their home-based funding, whatever, or still funding out of it." That's my only concern, is that Illinois will be really dumb and how to handle it, and they'll just say, "No, you're off ACA Medicaid, you're done." Their software is supposed to automatically then try and get you into other types of Medicaid, like ABD Medicaid, which they would qualify for and would still pay for things. But I do worry about the state messing this up and kicking people off Medicaid and not trying to re-put them into ABD Medicaid when they realize that they are morons and did not actually, the people that they put into ACA Medicaid don't actually qualify. So that's my only concern with it. Hopefully it won't be an issue because their software will work. And if it is, you just need to scramble to make sure that we get switched back to ABD Medicaid and say, hey, yeah, we're not, shouldn't be kicked out Medicaid, just switch it to ABD and call it a day. But again, we're dealing with a state, they may not even listen to you if you tell them I want you to switch it to ABD. They may still put up a stake and not do it. So unfortunately, it's Illinois.
Great, thank you. Thank you again.
Right. Hearing anyone else hands raised or any other questions in the chat box. So I guess we'll
Good.
say good nights and hope everyone has a good rest of the week and hopefully got a lot out of this. And take care and you all. Thank you for coming and listening to this.
Thank you very much. I'm going to put the link to the website in here again one more time. So I will hang out here for a minute. Someone asked for it.
Yeah.
But yes, so thanks everybody for coming. And thank you so much for the presentation, Benji. It was full of information. And that's why I wanted to announce that we will be sending out the recording and people can watch again if they want to review some of it or all of it. So, but great. Thank you very, very much for your time.
Thank
And
you.
thank
One other last thing, I just thought of in our calendar of events, you'll see the upcoming programs, upcoming speeches. There are some presentations where we have, 2.5 hours, 3 hours, a lot longer, and we'll go in more depth and have more time to discuss stuff. So if you want to either hear it again or hear it and sort of the guardianship piece a lot slower, for example, you can look at what the new events are, something like on our Zoom or in person throughout the state, Chicago, and even on Central Illinois, etc. So you can always look there. All right. Thank you, guys.
Thank you so much, everybody, for coming.